Firstly, let me say, before I call the member, the question is that the motion be agreed to, and now I'll take the Honourable Parakarahora.
Mr. Speaker.
Yeah, well done.
Tēnā tata. Mihi koina ki ngā kōrero tāriana. Nā te mea rochi āku e roro atu te tai o te kreme nei ki te wāhi nei, hei whakatika tātou te mahi raupatu, mahi tau, maha o te kāwana, e mahi atu ki wēnei ngā uri o Maraeroa. Mihi e tautokoti atu te mihi kia piripi, kia Glen, kia rātou mā. Nā te mea e pai ana e tai atu tātou matarangi nei, hei whakatika tēnei āka. Together, the bills today these two that we are discussing give effect to redress contained in the deed of settlement between the descendants of the original owners of the Maraeroa A and B blocks and the Crown for the final settlement of historical Treaty of Waitangi claims. The settlement bill records an apology to the descendants of the original owners of Maraeroa A and B blocks for historical acts or omissions of the Crown, including native land laws and the operation of the Native Land Court that led to the alienation of Maraeroa lands, like citing the harvesting of the indigenous native timber and the proceeds not being distributed, or the benefits to the owners at that so many years ago. And I want to join in congratulating Te Maraeroa Trust and Trustees, Piripi, Glen Katu, all of those people who put a lot of effort into making sure that they have got to this stage. It's also appropriate to recognise the contributions of officials and ministers present and past in the sense of the effort to bringing this reasonably complicated settlement to this point. Mihi atu kia koutou katoa. The settlement bill records the settlement package comprising a historical account, an apology and cultural and commercial redress, including the transfer of a number of sites of significance to the Maraeroa A and B blocks and corporation, an overlay classification over Pure Ora Kahu, which provides for the New Zealand Conservation Authority and the co-management and the authority given to the trustees in relation to the values and protection principles in relation to that area. As we said, the second part in the incorporation bill is something I'll discuss later on. The bill defines the descendants of the original owners of the Maraeroa A and B blocks as the collective group comprised individuals who are descendants of the original owners of the Maraeroa A and B blocks as identified in the orders made by the Native Land Court in 1886 and 1891. Any whānau hapu or group in the extent that it is composed of the individuals referred to above. It is interesting to know that the collective of the iwi of Ngāti Tūwharetoa, Ngāti Maniapoto, Raukawa and others affiliate to Ngāti Rereahu. So it's quite an interesting composition. And those people who belong to those other iwi and have other activities through a period of time have collectively come together and are supportive of the trust managing the affairs. The claims of the descendants of the original owners relate primarily in the operation of the Native Land Court and Crown purchasing, including the failure to ensure the owners, as I said earlier on, of the distribution. And one of the glaring issues was the huge harvesting of the native timbers that were very profitable at that time, and no benefits given down to those people. And there are elements of the settlement package in the bill that are quite interesting. Part 1, of course, sets out the purpose of the Act, but it records and acknowledges the apology given by the Crown. And there's been some difficulty in ensuring that that happens, and it's pleasing to see that we've got to that stage now. It also deals with related issues, including a consequential amendment to the Treaty of Waitangi Act 1975 and the removal of certain resumptive memorials. And this has taken a lot of discussion in relation to getting that out of the road. In Part 2, the statutory acknowledgements over the 12 culturally significant sites, which are very, very important to these people, and if anything, in the discussions, it's been put to the forefront in relation to the collective's needs. An overlay classification of Pure Ora or Kahu, which is important to them, which gives them much pride in the sense of getting it back to where it was before the Crown took ownership and did what they did. The two geographic name changes, which are very interesting, Manga Kokakotaya stream and Manga Paruoihoa stream have adjustments in the names. The vesting of the 6 culturally significant sites in fee simple, totaling approximately 1,789 hectares, are appropriate protection of public interests, conservation values and third-party rights, and they are well known for their environmentally aptness as an iwi who have practiced that long before it became fashionable, and they need to be recognised for that. The committee has recommended that the definition of sitting group in Clause 11 of the bill should be changed to include citations of dates and minute book references for the relevant judgments and orders made by the Native Land Court, so people are reminded through history of why this claim has come about. The second part that we're discussing today, the Maraeroa A and B Blocks Incorporation Bill, is really important, and the bill establishes the Maraeroa A and B Blocks Incorporation as a Māori incorporation and applies specific provisions of Part 13 of Te Ture Whenua Māori Act 1993 to the incorporation. The provisions applied relate to the constitution and powers of the incorporation and to its internal management. The Maraeroa A and B Blocks Claims Settlement Bill provides that the Maraeroa A and B Blocks Incorporation forms part of the settling group's post-settlement governance framework along with the settlement trust. It will obtain ownership of cultural redress properties. It will receive ownership of the licensed land, will have unrestricted capacity to dispose of settlement property other than that protected land that is vested in it, will have restricted capacity to dispose of protected land. Mr. Speaker, the effort that has gone into this, both by present trustees and people who aren't here to see these final days of this bill, has been enormous. And it is certainly one of the settlements that we should be excited about as a nation. It certainly toes along a very strong group of people who are kosher in the economic sense, but also not just culturally, but are certainly forerunners for not just Maori people, but New Zealanders in relation to their beliefs in preserving and working with the environment. Mr. Chair, the Labour Party supports this bill, these bills.
Speaker.
Honourable Chris Finlayson.
Mr. Speaker, as previous speakers have said, these bills are the result of a tremendous